So, big welcome to those that are on the call today. We know that you've taken time out of your hectic lives to be here. We're hoping that at the end of this session, you'll be more informed about what to expect at a mediation, information and assessment meeting. The acronym, of course, is MIAM. We're here because we're trying to, of course, promote awareness about family mediation, and that's what Family Mediation Week is all about. If we can have the next slide, and if we could do introductions to ourselves before we then dive into what a MIAM is all about and what the clients are going to expect. So Sarah, over to you to introduce yourself.
Thank you, Sushma. I'm Sarah Riddle, and I'm based in Sussex, and I'm a family mediator and also a child inclusive mediator and a hybrid mediator. And I also work as a family lawyer, probably splitting my work between being a family lawyer and being a mediator about 50-50. And I work with couples who are going through separation and maybe through other issues that they experience, even if they're not separating, and work online and in person, and in relation to both children and financial issues. And I'm also a collaborative lawyer. So over to you, Sushma, to introduce yourself and your expertise.
Thank you. So I'm Sushma Katecha. My background is that I did used to practice as a divorce lawyer for about 27 years. I gave that up over lockdown, just had the online family mediation and coaching service. I'm also a author. I published a book a couple of years ago. In fact, it'll be 2 years tomorrow, Holistic Divorce. The idea behind the service and the book is to actually educate those who are going through separation and divorce to understand and recognise that divorce is not just about your legal rights and responsibilities. It's actually looking at the process holistically, taking care of our mind, body, spirit and soul. I come from a place of knowing there's nothing like an awakening, stepping into the shoes of your clients. And I guess that was the impetus behind giving up law, the litigious side, and trying to promote a kinder, compassionate service for those who are going through separation and divorce. So you'd see at the end, the mission here is to empower those that are separating, to, I guess, take stock, to make mindful, informed decisions that's going to serve them, their children and future generations. If we can go to the first slide, the main slide, please. Over to you, Sarah.
Thank you, Sushma. So what is a MIAM? So MIAM is Mediation, Information and Assessment Meeting, very long term. So you might hear people about MIAMs quite a lot. Solicitors might mention it to you, or you may see it if you're doing Google searches. It's a term that comes up a lot. So it's the first step in the mediation process. And each person coming to mediation, it's often separating couples, not always. It can sometimes be grandparents and parents, where they might have some matters to sort out about seeing children, grandchildren. It could be a number of issues, but there are usually 2 participants. There can be more. Each participant has to have a separate MIAM with the mediator first. That's really important. That's so the mediator can speak to them separately, and each of those MIAMs lasts about 45 minutes to an hour. It can be longer, depends on your situation and the things that you want to tell the mediator, but roughly about an hour is the usual time. The purpose of it is so that you can share details of what you're concerned about, your worries, your situation with a trained mediator. And the mediator will spend time listening to you and will then have a number of things that they need to go through with you to make sure that mediation would be a suitable process. It's not suitable in every case, and so it's important for the mediator to really hear from you about what it is you need to sort out so they can make that decision with you. The other points of the purposes of the MIAM are for you to understand what the mediation process involves in practical terms. We're going to talk about that a little bit in a minute. And also to have an overview of the other non-court dispute resolution options, because there are a number of other ways you can work in family law processes and with therapeutic professionals to help you if mediation isn't right. So it's important you get an overview of everything, and the mediator can provide that for you. Very importantly, the mediator has to assess whether it would be safe and suitable to mediate. So you will be asked a number of safeguarding questions, which can seem strange when you would never have thought there were any safeguarding issues in your case, and for many people there are not. And even if there are, it doesn't mean you definitely can't mediate. There are other ways of mediating that would be tailored to your needs, but it's important, that's an important purpose of the MIAM, to check safeguarding. The other purposes are to look at the most suitable model of mediating in your particular situation. Not everybody wants to be in the room together, so there are other ways we'll look at briefly in a minute as to how we could tailor it to your needs. And finally, so that the mediator can give you some guidance on the options and the next steps that you can take to progress through your case on your separation journey, people often call it that, and information and bespoke resources about other organisations or advice that you may need. It could be financial, it could be relating to children, it could be therapeutic support. A lot of different resources can be provided by the mediator in the MIAM or in a follow-up email after, or it may be on their websites. So that's just a very brief overview of what a MIAM is. So if we could have the next slide, please. And Sushma, over to you.
Thank you, Sarah, for that. So, and I guess the key thing, following on from what you just said about a MIAM, it's a safe, supported environment, confidential process for those that are starting off on the separation and divorce journey. So how do we actually start the mediation process and get the ball rolling? So this slide is just to explain the steps that you'd have to take to instruct a mediator. The first thing that you need to do would be making a referral, and it's either yourself, if you are going to be making the contact first, as opposed to instructing a lawyer, or sometimes your lawyer will make the referral on your behalf. These days, most mediation service providers have an online form that you'd be completing, but you can make an inquiry via email or on the phone to see what the process is. Once the referral is made, of course, the next step is to book in a mutually convenient time with a qualified mediator for your separate assessment meeting. And again, depending on the service provider, either it's going to be undertaken where you would be telephoning the service and asking for a mutually convenient date to be placed in the mediator's diary. You may be then paying for the session at the time, at the point of making the actual assessment meeting. Occasionally, there are some service providers who would probably ask for payment afterward, but most of us, I think, are inquiring for payment ahead of the session. My particular service is automated, so everything's online. So you'd actually then go into my actual diary and book in a session that's mutually convenient, so that at the point of making the booking, you would then receive the documents to help you prepare for the assessment meeting. Now, one thing to understand is that I'm talking about fees, but there is, of course, legal aid mediation, and we're going to talk about funding shortly. But just to say to those that are qualified for legal aid family mediation, you would not be required to pay for the cost of your MIAMs, certainly so long as one of you qualified. Both of you'd get your MIAMs free. And from my understanding, the first session would then be without any cost to both of you. If one of you don't qualify, my understanding is that person would then go on and pay for the costs. But the legally aided participant would continue to receive those services under the legal aid scheme. Now, it's important to understand that since the new standards came into place, the initial separate assessment meetings would need to be conducted separately. Historically, there was an option to carry out MIAMs on a joint basis, but the standards that were issued through the Family Mediation Standards Board a couple of years ago made it very clear that from now on, or as from the date those standards came into place, we need to ensure that the MIAMs are undertaken separately. Now, meetings can take place virtually or online. So again, depending on your preference, we would also advocate to those on the call to make inquiries with the service provider so that you know that you're getting the right mediator to match your needs. Some people don't like the idea of being on a virtual screen, so therefore my service would not be suitable to you, because mine is a purely online service as opposed to Sarah's, where she's able to offer both in-person and virtual appointments. Finally, just want to touch on the fact that there is a legal requirement for parties to attend a MIAM. So there is effectively a pre-action protocol, which was enhanced by the Family Procedures Rules that came into effect in April 2024, which is effectively saying that unless you're exempt from attending a MIAM, you must make a booking with a qualified mediator so that you can get all the tools, resources, knowledge and information on all your options before you decide which way to take. And the thinking behind this pre-action protocol is to try and save people the heartache and the costs of going down the court route. If there's a kind of compassionate way, if there's other non-court dispute resolutions options that serve you better, it's going to bode better for the whole family moving forwards. The exemptions typically are if there was any significant welfare issues in relation to the children or severe domestic abuse, you know, an equal bargaining power that may not be able to be redressed by the mediator. In certain circumstances, those exemptions may well apply, you know, from the outset. I don't know if Sarah wants to add anything onto that, but we'll go on to the next slide, please.
No, that's fine, thank you. I would just a slight add on to what Sushma said is if you're wondering how do you find a mediator, the Family Mediation Council website has a register of mediators, and the MIAM itself can only be signed off if you needed a certificate for a court application by an accredited mediator. So you will see on the Family Mediation Council website which mediators are accredited. Other mediators who are not accredited but working towards it can still do the information meeting, but they would need a supervisor to sign off the certificate for them. So that's just a brief aside, I think we touch on again later. So back to the benefits of a MIAM, which is the title of this talk. So there are many benefits. This is just a summary of the main points. It's a comprehensive resource. So I think many people hear the term mediation information and think it's only going to be about mediation, but actually it's a very wide-ranging meeting. And it's one of the few places you can, or few ways you can find out all in 1 hour, basically, hopefully the main things that you would need to know to decide what to do next. So often it's a really helpful resource for people who are unsure, they're overwhelmed, they don't know what to do next, to come and have a chat with a mediator. It's a very informal meeting, it's private and confidential, and it's a way for you to explain what your situation is, and the mediator will structure the discussion in the MIAM to try and guide you through the options, and it will be up to you which of those options you want to take, but the mediator can provide useful tools, resources, links to information which they can send you after, or they can direct you to their website, and they can signpost you to other organisations. It's a customizable arrangements that are discussed in the meeting, i.e. its mediation is tailored to your needs. So there's not a one-size-fits-all. Mediation is very much a flexible process, and that's why you'll find in the MIAM, the mediator will be listening to you at the beginning. They will interrupt if they want you to tell them certain things that you might not have thought of immediately that were relevant, but they're trying to find out what's going to suit you best rather than just fit you into a sort of more generic way of working. So that's important to know. Mediation is voluntary, and so is the MIAM. Nobody can actually force you to come to a MIAM, but following on from what Sushma said about the pre-action protocol, sometimes your first thought when you have a problem in a family situation and tempers are flying or feelings are riding high, you think, I need to go to court and sort this out. So now court is very much a last resort. Judges and courts are promoting mediation and non-court route resolution methods because the courts are overwhelmed. There's a huge backlog. You can be waiting many, many months to even start your court process and certainly to conclude it. It's very stressful. You don't have control of the decisions anymore, that somebody makes them for you. So by participating in mediation, it doesn't work for everybody, but it's a way for you to choose to take control of the situation, or to try to do that with the support of a mediator and the other professionals that are involved. So in the assessment meeting, the mediator will be looking at whether it's going to be safe and suitable for you. And mediation can work in conjunction with other processes. So It might be that mediation is part of your story. It might not solve everything, but it's a good thing to consider. It's a confidential process, so the MIAM will be confidential between you and the mediator, except for exceptional circumstances, which Sushma's alluded to. So if there was an urgent relocation issue with a child, for example, or urgent financial issues, somebody was going to, for example, use or transfer an asset over which you had no control, those sort of things are really urgent, and the court will still be probably the place for those. But most cases don't need an immediate court application, and it's worth taking the time to sit down and talk to a mediator in a MIAM about the other options. So this meeting should hopefully give you all the information and guidance you need to navigate the next steps in your journey. So hopefully that's just given you an overview there. Sushma, if we could have the next slide, Alicia, thank you.
Thank you.
Sushma.
Just to follow on from what Sarah's just said, the main thing to understand is at the end of the MIAM, you're only going to have the opportunity of mediating if the mediator has assessed the case as safe and suitable. And then it's totally up to you. If it doesn't feel right for you, the body, normally has an indication for you once you've met with the mediator, is this going to work for me? Even if they assess it's safe and suitable, if you don't feel it's going to work, that's the whole point, that it's totally voluntary. There's going to be no obligation to then mediate. And when we do complete those MIAM certificates, it's totally confidential. So nobody's going to know which party declined or whether it was the mediator's assessment that it's not suitable. So I think that's something really important for those of you that are on the call to be aware of. So now coming on to MIAMs and myth busting. So, quite often you're sent off to attend a MIAM from some lawyers, not all lawyers, on the basis that it's simply a tick boxing exercise. You've got to go to a MIAM so you can get this, form completed so you can head off to court. We want those on the call to understand and recognise that, this is a standalone meeting that should bring a lot of value to the table. It's not just a tick box exercise. We've just explained that we go into a lot of detail to try and understand what you're going through, how to meet your needs, and to give you tools, resources, and information so that you can make an informed decision as to what's going to work for you. And there are obviously some cases where no forms of non-court dispute resolution are actually going to help and serve and support you. So we'd probably estimate about 30% of cases do need to be conducted within a courtroom setting, but I'd say 70% certainly where there's a will and commitment, open mindset and heart set from those participants to go and work in a creative way, outside of court. So please don't think of a MIAM as a tick box exercise. Know that you're going to get value for your money and your time and energy in showing up. The other myth is that mediation is not going to be suitable for high conflict or complex cases. That's far from the truth. There are upcoming models which allow for very complex and high conflict cases to be undertaken within the mediation forum. We're going to talk about those models shortly. The key model is the hybrid model, and of course that can involve shuttle mediation, which I think Sarah touched on, where you're not actually sharing the virtual or physical space with your ex. The important thing to understand is that not all mediators are qualified in the various models of mediation. So if you know within your own heart and mind that, what, mediation might work, but it needs to be shuttle, or I need to have the opportunity of having my lawyers engage because I'm going to feel more comfortable in that, then you do want to be searching for a lawyer who's qualified and to undertake the hybrid mediation model and offers the shuttle mediation model. There's also a myth about, once you attend a MIAM and you go down the mediation path, that's that you're not going to need lawyer engagement. That is, again, far from the truth. Mediation works best when we're working with lawyers hand in hand. Obviously, there's the affordability. You've got to have the capacity to afford legal services. But we would always advocate as mediators that, get some legal advice at least. And I know that lots of lawyers are offering, free or fixed fee sessions. When it comes to actually ratifying and making legal those agreements in mediation, which of course are confidential, they're without prejudice, they're not legally binding, you are going to need lawyers to draft the paperwork unless your mediator is a qualified lawyer who undertakes the paperwork for you. So again, not all mediators do that. Certainly I don't, and I'm not sure whether Sarah does draft. No, she doesn't. I think most mediators are of the view that they would rather prefer that particular aspect of work is undertaken through a separate entity, a separate lawyer. So do bear in mind that there is going to come a point in time, particularly when it comes to financial arrangements, that you will be needing to seek the services of a lawyer to get the paperwork in place. Now, when we're reaching agreements regarding child arrangements, most of us are empowering those of you that choose to come to a mediation service to co-create their own parenting plan. There's lots of free toolkits out there, that serve and support you. I know that our Family Wizard app, where Alicia is here from Our Family Wizard, they have a parenting plan template, as does the CAFCAS website. So CAFCAS is the body, the institute, which will be undertaking the initial safeguarding checks and reports for the court if it ended up in court. They have a fantastic parenting plan, which I often share with clients to empower them to then formalise arrangements within that parenting plan, which evolves and grows. Because let's face it, our children, depending on what age they are, if you're coming to mediation when they're young, we've got to meet their needs, and the arrangements are not going to be static. They're not going to be cast in stone. So that's helpful to know. And as we've already said throughout this talk, the purpose of the MyAM is to get valuable resources of information, for the safeguarding checks to be carried out, and of course exploring all the host of non-court dispute resolution options that there are. Mediation is the main one. We've got early neutral evaluation, we've got arbitration, there's collaborative law, which the mediator would go into some detail with you, at the meeting, as well as sharing the information possibly before or after, so that you can really take time before you decide which way to go. That's this on this slide. Next slide, please, Alicia.
Thank you, Sushma. So Sushma's touched on the funding and costs of mediation and MyAMS already. So just to go into a little bit more detail, legal aid is available if you're financially eligible for the cost of MyAMS and mediation. So unlike legal aid for legal advice, where you have to meet certain strict criteria as well as be financially eligible, for mediation, it's your financial eligibility which is relevant. And if you are eligible for legal aid, you won't have to pay back the legal aid funds that have been provided to you for mediation at the end of mediation, whereas in legal advice cases for finances, it's likely that you would have to. So if you are eligible for legal aid, just slightly repeating what Sushma said to be clear about this, you would, even if only one of you is eligible, you would both be able to have your MyAMS for free, covered by legal aid, and you wouldn't need to pay those fees back. And if you decide to go ahead with joint mediation, your first joint mediation session would be free, covered by legal aid for both of you, even for the person who's not eligible. But going forward from that, as usually one mediation session is not enough, typically you might need 3 to 5 sessions depending on your issues, but it varies from couple to couple. From the second session onwards, if one person isn't eligible for legal aid, then they have to pay their 50%, but the other person continues to obtain legal aid. So it's very important to think about whether one of you might be eligible for legal aid at the outset. That does restrict your choice of mediator. So as I mentioned before, you have to look at the Family Mediation Council website, where there's the main register of mediators available. And there's a box there you can tick to make your search for the mediator that in your area, who can carry out MyAMS. And there's also a box to tick to check whether they are able to offer legal aid, and it will be on their website. So at the point when you contact them to see if you can make an appointment, they will make an assessment, possibly at the first meeting, but likely to be before that, so they can see how your costs can be covered. So that's relevant for some people. If you're not eligible for legal aid, the limits are very limited these days, so it's quite hard to get legal aid. You're probably aware from things which have been in the news in recent years. There is the mediation voucher scheme, and I'm very pleased to confirm that we just heard in the last few days that the government have extended this for a further year. It was due to end in March 2025. It's been reviewed, and we know for at least a further year, maybe beyond that, but a year at the moment until next March, couples will still be able to receive £500 as a one-off, non-means tested benefit to help them with the cost of the joint mediation. And that is presently, that's in cases where they're discussing child arrangements.
Mm.
So you can have meetings which cover finances as well, but child arrangements have to be a significant part of your mediation to obtain that voucher. The mediator applies for that for you, so no money changes hands. You don't need to worry about applying for it yourself. The mediator will apply for that for you, and most mediators are registered for that scheme, so they will tell you about that at the MIAM. Importantly, the mediation voucher does not cover the cost of MIAMs, so you'd still have to pay for MIAMs, or if you were eligible for legal aid, and one person wasn't, the £500 could be used later on in the joint mediation to help the non-eligible person, potentially. So that's a bit of a quick overview. It might sound a bit overwhelming, but there is some information online on the government website about that, which makes it clear. And if you've got any questions at the end, you can ask about that. The typical costs of a MIAM, they range widely because for most mediators, many mediators are lawyer mediators, so they might have a higher hourly rate because of the way that their firms are set up. There are some organisational mediators. There's often not much difference between the lawyer mediator fees and the non-lawyer, but you might find a variation. So you can ask, you can find out, you can look at a range of mediators in your area. And I would stress that it's really helpful to go to the Family Mediation Council website, put your postcode in under the Find a Mediator tab, tick the boxes to set the filters, and you will find a range of people. You can look at their profiles and see who you think is going to be best for you. You do have free choice in that. Obviously, the other person has to agree with who's going to be chosen, but hopefully you can work that out together. So yeah, private joint mediation fees can range from £120 to £300 plus VAT per person. Most people do it on a fixed fee basis, so you know exactly what it's going to cost up front. I think occasionally some mediators might do an hourly rate, but you need to check that at the beginning. Sushma and I do fixed fees, so what they were. The MIAM certificate, Sushma alluded to, this is the other purpose of the MIAM. If mediation isn't suitable and you need to go to court, then the mediator can be asked to provide a MIAM certificate to you, so they can sign your Form A if you're making a financial application, or your Form C100 if you're making a children application. Normally they'll want to consider with you whether they should invite the other person first, to give that person an opportunity to think about mediation, to be sure it's absolutely necessary for you to go to court. But in some cases, you just might not want to mediate with the other person, and you should feel free to tell the mediator that, so that you can consider the timing of signing the MIAM certificate. Once a decision's been made that mediation is not going to be suitable, that could be at the MIAM, if there are pressing issues to be decided, or it could be a little bit later on when we know whether the other person's going to participate. About 4 months from when the MIAM process has finished, that's the time frame within which the mediator can provide that MIAM certificate. After that period of time, you're likely to have to go and get an updating MIAM because the court wants to be sure that your MIAM information is up to date. So the mediator will explain that at the MIAM for you. I think that's all.
Just to clarify, Sarah, the MIAM certificate is only valid for 4 months from the date of issue. That's something that those that are securing these MIAM certificates need to be very clear on. If they do want to go to court, if they need to go to court, then please go ahead and issue within that 4-month time span of the certificate, certificate's date. Because then if you then come back to the mediation service and say, can you just update the date, it's not what we're allowed to do, you would then need to book in the MIAM. So that's important to be clear on, I guess.
Yeah, thanks for clarifying. That's completely right. Thank you, Sushma. So I think that's all that. So the next slide.
Children and mediation. So this is a key and hot topic. So we're very keen to educate and make people aware that there is an opportunity to consider child inclusive mediation. So this is to have the child's voice heard within the mediation process. So research has shown that those children that have been through the court system, they are not happy. They're disgruntled about the fact that they are not being, allowed to take part in the process, have their wishes and feelings heard, and they don't feel like they're having a voice. So very important where we've got children of a certain age, and typically within the child inclusive mediation model, we are seeing children who are, age 10 and above. But if they've got, slightly younger siblings, and you've got, the others that are elder, then there is an opportunity to see the younger siblings. What we need to understand is that not all mediators are qualified for child inclusive mediation. So Sarah's got the certificate to carry out child inclusive mediation. I haven't as yet undertaken that additional string to my bow, but I do co-mediate with other mediators where, this is what is considered appropriate as a step forward. Now, you can only undertake child inclusive mediation where you've got consent of both parties, firstly, to approach the children. So in my case, if I'm working with a co-mediator is qualified to undertake child inclusive mediation, I need to get written consent from the parents, number one. And quite often the hurdle falls there because not both parents do want the child to be seen by a child inclusive mediator. But if they do, if they're both on board and the parents consent, then of course that child inclusive mediator in an appropriate way is going to make contact with the child or the children. Now it's up to the child or the children then to give consent and their willingness to participate in mediation. The mediator will have the skills and the requisite qualifications to communicate in an appropriate manner, to explain what the press is about, to reassure them that it's a safe, supported environment, totally confidential. Whatever they say to the mediator will not be fed back to the parents unless they give clear consent. So quite often children do like the idea of having a professional support and an outlet to have their feelings and voices heard, but they don't always give consent for information to be passed to parents, and quite often it's just one nugget of gold that might be agreed for the mediator to pass on to the parents. What else was I going to say to you? I think we've got, there's additional costs, of course, associated with the child inclusive mediation. Now, the £500 voucher that we've just talked about, and it's music to my ears that it's been extended, because certainly I know from my experience, and I know having spoken to Sarah previously, that we find that these vouchers are invaluable to those, that do qualify. It's a gift which most parents don't want to kick in the mouth, and they will at least experiment. So where the mediator has assessed a case as safe and suitable, they know they've got this voucher, they are more than likely to give mediation a go and experiment with that. And again, of course, it depends on the hourly rate of the mediation services to, how long your session is going to be. Just for example, my hourly rate is £250. And so that would allow participants up to 2 hours free mediation, which is quite often more than enough to set them on the road to working together without ever needing to see a mediator or a lawyer again. So very invaluable. But on that point, if you have the opportunity to apply for the voucher and you don't use it for a joint session, my understanding is that you can use it towards a child inclusive mediation cost if you wanted to. I know that there is some talk down the line if we can persuade government to give us, a standalone voucher for child inclusive mediation. That's obviously still to be seen. We know that what's going on with the government, the purse strings are very tight at the moment. But I don't want to knock the fact that we've actually had the extension for at least another year, so that's brilliant news. I don't know if you want to add anything to this, Sarah, because of course you're qualified within child inclusive mediation, before we go on to the next slide.
Only just briefly to say that the child inclusive mediator can be the same mediator that the parents are using, or it can be a separate mediator that's dedicated just to the children, and that mediator comes back into the session to feed back to the parents mediator. And the messages that come back from the children, if there are any, they must be specifically relayed to the parents in the children's own words. And this child inclusive mediator will work through those with the children to make sure the children are happy with it. The children need confidence that their views are going to be relayed in the way that they would wish them, without any interpretation by the child inclusive mediator. And anything else beyond that cannot be shared with the parents. That's to give the children absolute trust in the process. The parents have to sign a consent form before the child inclusive mediation to agree that they will not question or prepare the children, prime them in any way beforehand, and afterwards that they will not be angry with the children or delve into what happened if they didn't perhaps like or were surprised at what they heard. So most parents who are willing for child inclusive mediation to take place definitely abide by those precepts. So it's but it's important. It's a serious thing for children to be asked for their views, and they need to be respected. The voice of the child is now considered in all family law processes to be incredibly central and important.
Yeah. And I guess finally, before we go on to the next slide, important to understand the confidentiality of that process. So if mediation broke down, if one or both parents weren't willing to take on board what's fed back, then you can't use any of this in any future proceedings. So very important for people on the call to understand that, right?
Yes, absolutely.
Next slide, please. Thank you. Over to you, Sarah, on the different models.
Thank you. I can see a question has just come in the Q&A about this, so we can always follow up with the Q&A at the end. But so there are different ways of mediating. There's what we might call classic mediation, which is probably the majority of cases where it's potentially two parents, two participants in the room with a mediator on their own, talking together, and the mediator is facilitating the discussion. They're impartial, they can't give legal advice, but they are there to give legal information. So that's the classic mediation, which most people participate in. It's flexible, even in classic mediation. So if somebody's overwhelmed or needs a break, the mediator will be able to take a break. And I know how I work. I don't know if it's the same for everybody. I will hope to kind of intuit if somebody's feeling stressed or overwhelmed, and I will always have booked a separate room if we're in person, or set up a breakout room so that I can spend a little bit of separate time with each person to just get back on track. So that's the main classic mediation. There is also co-mediation. I'm just jumping to the second one here for a minute, where two mediators can work with the couple. That's less common, but sometimes it's helpful. Mediators all have different specialisms. Some might be more used to working with people with neurodiverse issues. There might be some who have different first language. There's a number of issues that some mediators may have developed a specialism in and be renowned for. So occasionally couples may say, I'd actually like to work with two mediators, and that will be fine. So that's possible. Hybrid and shuttle mediation are where you're largely in separate rooms. So shuttle mediation, you'd probably be in separate rooms for the entire mediation. Otherwise, it's the same principle as classic mediation. The mediator is impartial. They come and go between your rooms or your breakout rooms if you're working online, and they try and allocate time as evenly as possible between both of you to find out what it is that you want to say to the other person. They try and stick as far as possible. You'll probably find them with a notebook when they're going between the rooms, and making sure they take a note of what it is you want to say, and as close as possible will deliver that to the other person in your words, because a lot can be lost in translation. Shuttle mediation is a useful way to work where people are in high conflict. I've used it, for example, where people, very occasionally, where people have, one person is perhaps, there's been a non-molestation order, someone is subject, for example, to bail conditions or an order not to have any contact with the other person. You have to think very carefully and plan ahead whether mediation is going to be suitable in that scenario. But sometimes, despite what's happened, parents still prioritise their children. They want to have a way to talk neutrally about them, but they can't be in the same room. So safeguards have to be put in place. The court has to vary the bail conditions or the non-molestation order to allow that to happen, but it is possible occasionally. So just to let you know, it's not a barrier if you think, I couldn't even think about mediation because of this. Hybrid mediation is something where a mediator will have had a separate specialist training to be able to deliver this model of working. So hybrid mediation is a little bit like shuttle mediation. You don't have to be in separate rooms throughout, but probably a lot of the meeting will be with you in separate rooms. We can come back together at certain points in the meeting. It can be online or in person. With hybrid mediation, you can bring your lawyers with you if you want to. Sometimes you might start in classic mediation, but it gets stressful or overwhelming. There can be complex issues maybe, and you feel you need legal support. So we can convert the classic mediation into hybrid mediation if the mediator is trained to work in that way. So it's commonly used potentially where people are already in court proceedings and they want to pause the court proceedings and maybe work together in hybrid mediation. The sessions are often longer than classic mediation. Classic mediation might be 1.5 to 2 hours a session. Hybrid mediation might be half a day or longer. It's a bit like civil mediation that businesses or people with boundary disputes or employers might. It's the mediator is really the difference. Main difference is the mediator takes time with each person to explore in more depth what their bottom line might be if they're negotiating finances, and how far they're prepared to go. And then they will go to the other person and they won't reveal how far the first person's willing to go, but they will share the bottom line. They will hear the same information from the other person, and in that way they will try to move the parties closer. So it's quite difficult to envisage unless you're in the process. And there is a lot of information online on the resolution website, and I believe some on the Family Mediation Council website as well, and certainly on my firm's website or other websites. So it's a very useful way to work, but it's in a smaller amount of cases. It's increasing because it's becoming a way to avoid the court process, because many cases can be resolved in this way with lawyers' support available. If you don't want to bring lawyers because it's cost prohibitive, you can bring a trusted third party with you. I've had people bring their father, mother, cousin, trusted friend, provided the other person doesn't object to that. That third party is not going to cause mayhem and try and derail the process. That's also possible. Or you can come on your own to hybrid mediation and just be in a separate room. So it works in many ways, and it's a very good process to bear in mind where there's high conflict and you don't feel you could be in the same room. So mediation will be tailored to your needs. At the MIAM, the mediator will have a better idea of what's going to be best and possible. Finally, interdisciplinary mediation is where a family consultant or a financial neutral can be involved in mediation. These are professionals who are not legally trained. They're therapeutically trained. The family consultant is therapeutically trained. They're not there to offer you therapy. They're there to help parents with communication issues, help you formulate a parenting plan. They can help you between the main mediation sessions and keeping on track, ironing out glitches. If you've come to a point where you're stuck, you can meet with a family consultant between the main mediation sessions or jointly with the mediator, just to try and drill down into what's going on here, because a lot of it's to do with emotions, not just facts. So I do probably half my mediations at least jointly with a family consultant, and that way of working, it might be more costly up front because you're paying for two professionals to work with you, but overall it will probably shorten the mediation process because we can work through a lot of issues with you both jointly. So it's a very good way to work, and we can have separate time with each of you. The financial neutral, just very briefly, is someone, usually an independent financial advisor who's got a special training in working with couples to help them jointly or separately about pensions, mortgages, a number of issues to help them alongside mediation with the process. So yeah, as I've just said, the NB at the bottom is mediation costs can be higher if you involve these other people, but likely to have less meetings because you can get through a lot more in the meeting with these added resources. So that was a whistle-stop tour through. I hope I haven't overwhelmed you on that, but there's a lot of information online, and do please ask at the end in questions. So Sushma, over to you for the next.
Thank you. I'm conscious of time and we need to make sure we have got time for questions. I think we've got 3 slides left, so we're going to try and get through those as quickly as possible. So tips, I guess, in preparation of your MIAM, you will receive a pre-session questionnaire to complete. If you can complete those and send them to the mediator in advance of your MIAM, it's going to be very helpful because it saves you as having a Q&A, and we'll have some information about your particular circumstances ahead of the meeting so that we are prepared for the MIAM from our side, and quite often those that are serving you as mediators, they're going to give you some documents, information to read ahead of the MIAM so that you're prepared. It's very important to bring a list of questions to the discussion because, you know, as we've just said, going through divorce and separation, it's an emotional journey that we're going through. We may not be able to think straight at the meeting, emotions may come to the surface, and you don't really want to forget key questions that you might want to ask the mediator. So if you can make a list of questions, and we can do our best to alleviate any of those concerns and you know, signpost you if we can't help, you know, with the questions that you've got. But that's the whole point of a MIAM, is that we should have a host of, you know, tools, resources and other professionals that we can signpost you to if we can't for any reason be that for you. The next thing, of course, to understand is that a MIAM is, as we've said, an informal and a confidential session where we're gathering information, where we're trying to find out how we can help you. And that's where it's important that you complete that pre-session questionnaire, because the more information you give us, the more that we're then able to help you in terms of what options we can give you as the best way forward. Now, at MIAMs, you know, most mediators will be happy for you to bring a friend or a relative at that session to support you at the meeting. But just coming back to what Sarah was saying, you know, about the different models, I practice the traditional, you know, mediation model where I am empowering and serving and supporting couples to actually have the degree of trust and faith and build communication. So I'm really working with couples who are willing to work together on the same screen. And so moving forwards, my model is very strict that, you know, you would be coming to the session where you're both on your own, and it's an online service. So there's additional rules that you're signing up to say there's nobody with you, that we're going to maintain the integrity of the process, that we're not recording it. But as we've said, if you prefer a different model, then you've got to make sure you get the right match for you in terms of the mediation provider. That's why it's important to perhaps speak to 2 or 3 different mediation services so that you can understand what they're offering and does it align with what I need or what we need in terms of meeting, you know, our joint needs as in the couple that's going through divorce and separation. So next slide, please, over to you. I think it's for after the MIAM. Yes, Sarah.
I'm just going to really skip over this quite quickly because I'm conscious of time. There's a couple of questions, not too many in the Q&A. So after the MIAM, hopefully you'll feel better informed to consider the options that you've been provided with by the mediator and take time to reflect and decide what's best for you. You can follow up with the mediator if you need to, if there's something that you're troubled about, and they will help you decide what to do next. The mediator can signpost you to additional services if needed before joint mediation, which can be financial advice, therapeutic support, or legal advice if you haven't already found a lawyer, but you may have one. The resolution website is a very good one to go to if you're looking at finding a lawyer in your area, and that includes lawyers who offer legal aid as well. Arranging joint mediation sessions. Many couples feel ready and quite happy, pleased, relieved to be able to go ahead with joint mediation once they've both had their MIAMs. And so a mediation meeting might be arranged within a matter of days after that. But it will depend couple to couple, everyone's different. So the mediator will be able to set up the arrangements for you quite quickly if that's what you want, but it's taken at your pace. If mediation isn't suitable, the MIAM certificate can be issued by the mediator. Either your solicitor lawyer will ask the mediator to provide that for you, or you can ask the mediator to send it to you. And you can come back to mediation or start mediation during court proceedings. Put on hold. So that's just very briefly after the MIAM, those are the various outcomes. So I think we just maybe have 1 or 2 slides, Liz. Yeah.
Just 1 slide left now, I think, is on the benefits of mediation, if I'm right. Yeah. Just to touch on what Sarah's just said in relation to what slide are we on ahead of this? Sorry, I've just lost my train of thought.
After the MIAM.
After the MIAM, yeah. Yeah, just to make sure, just come back to the fact that, you know, mediation can be considered, as you've said, throughout the process, even if you're in court. In fact, coming back to the new pre-action protocol, the family procedure rules that's come into play in April, there is this whole microscope. So if you are, you know, with lawyers in litigation, I know there's something called a Form as the FM5, Sarah, that lawyers have to complete.
That's right. Yes. Yes.
So just thought I'd highlight that you know that there is going to be this whole microscope on considering non-court dispute resolutions alongside litigation for those where the court might consider that it is safe, it's suitable. Why are you in this path? So coming to the values of mediation, just to end this talk, and it's important for us to sort of shine a spotlight on this because we're trying to advocate, mediation is a way forward. So, firstly, not only does it help you make arrangements in relation to parenting, property and money, but I would say most importantly, mediation allows you to talk about softer topics and issues like boundary setting, like building trust and communication. Certainly, from my point of view, I'm qualified as a holistic life coach and mind-body practitioner. For me, it's very important to, try and provide these tools and skill sets to clients to get back to a way of having some form of civil relationship, especially where there are children, because communication is the key. So over to you, Sarah, for the next couple.
Yes. So it's hopefully a more cost-effective method than going to court. It should definitely be, because court proceedings are very expensive. Even if you get legal aid, you may have to pay some of that legal aid back at the end of the case. It should allow you to resolve things much more quickly. Mediation can vary from couple to couple, but things can be resolved quite swiftly once you get your heads together, and with the added support and resources that we've mentioned. And I would just, before I go back to Sushma, I would just add on that it enables you to stay in control of the outcomes and make decisions yourselves, because if you go to court, a judge that doesn't know you, who's just involved with your family for a very short period of time, will be forced to make a decision for you because you haven't been able to come to a mutual understanding together, which is what you can do in mediation.
Indeed, indeed. And finally, where there are children, of course, whilst the mediator is third party neutral, doesn't take the side of either mum or dad, we do take the side of the children. So we're encouraging you to step into the shoes of your children, be very child-centered, in the hope that you then make decisions, of course, which are going to serve and support them as well as you moving forwards. It's a kinder, compassionate way, and it allows you to move on to the next stage of your life, I'd say, in a more dignified way, if you are able to both commit to the process. Finally, I guess on this slide, it's just to highlight the point that, ideally you should be seeking to hire the services of a registered family mediator with the Family Mediation Council, as we've been saying throughout. I think we've come to the end of the session now. We can see if there's any key questions that we may need to answer.
I think some of them might have been touched on in the discussions we've had. So we might not get through all of them, but perhaps we could cover. I think, Alicia, you're going to.
Yes, of course. Do point me if this has been covered already. Does legal aid only offer classic mediation?
No, legal aid is available for, so provided your mediator is has a legal aid contract for mediation, which there aren't so many firms that do, certainly in my area of the country, but it varies where you are, and you would know that from the Family Mediation Council website. The mediator can apply for legal aid on your behalf for mediation. What it's not available for, it's probably easier to say, it's not available at the moment for child inclusive mediation, as far as I'm aware. So whether the mediation is doing hybrid mediation, shuttle mediation, or classic mediation, or co-mediation, or interdisciplinary mediation, all of those ways, the mediator costs could be covered by legal aid if you are eligible for that. So, but just not the child inclusive mediation. That may change. I think Legal Aid Agency are looking at that.
Lovely. Thank you, Sarah. I am aware that not all mediators allow legal aid, but do all accept the £500 voucher where children are involved?
You've got to be registered for the scheme. So that's the key thing, is that, please do make your inquiries. So that is a gift, isn't it, to going through divorce and separation. So we would say, please go onto the, their website, wherever you're looking to seek the services of, and see and make inquiries. Are they registered? So on my frequently asked questions page, I will confirm that I am registered, but really important to know that not everybody is.
And if
but know that me and Sarah certainly are.
Yeah. Yes, no, that's right, Sushma. If you're looking for a central place to look at the FMC website, you can tick the box to see whether the mediator would have that voucher available for you.
Lovely. Thank you both. What qualifications are there for hybrid shuttle models? I wasn't aware of any specific qualifications for that aspect.
So I think I touched upon this. A hybrid mediator would have to undertake a specialist level of training to be able to conduct that sort of mediation. Shuttle mediation, there's no separate qualification. There's not a massive difference between shuttle and hybrid. They're largely in separate rooms, but the hybrid involves a greater depth of exploring your situation with the mediator when they're in separate spaces with you. So it's a lot more like a civil mediation model. So it does require that extra level of training, which not all mediators have. So you may want to check that at the outset if you think that's going to be likely to be helpful for your case.
And just to touch on the shuttle mediation and the different models, again, it's just the audience to be very clear on, not everyone's going to offer every type of service. And I'm just going back to myself because I know that I've experimented with shuttle mediation online and it's proved to be disastrous. So I'm saying to those that are choosing to work with me, I would offer you a service so long as you're willing to share virtual space. And I will make sure that I'm, protecting, or doing my best to ensure that it's not counterproductive. It doesn't become, too high conflict or the emotions are too high, because we can take time out and I can manage that. So long as they're willing to work together, as Sarah said, occasionally we just need to take a breather and then come back into session. Are they still willing to continue? And if they're not a problem, because mediation is voluntary throughout. So none of us know, none of us have a crystal ball. We might assess a case as safe and suitable. Two participants might say they want to mediate, brilliant. But sometimes it just doesn't work, but you've given it a go.
I think Sushma might have frozen there.
I might just jump on to the next question, Sarah, if that's okay.
Yes.
I think we've got time for just two quick more ones. How do you handle a situation where trauma responses are triggered in a client by the process, including providing information for the MIAM, where there is ongoing coercive and controlling behaviour, and this trauma response affects a client being able to represent themselves?
That's a big question, but they're common themes which come up more regularly than you might think. People have been through a lot by the time they come to the MIAM, and the mediator might be the first person they've actually spoken to about their trauma and how they're feeling. And coercive control is obviously a very serious issue. It's a crime. So it's taken very seriously. So part of the mediator's safeguarding checks will be honing in on this. And it is important just to say briefly that if it comes to light in the MIAM or even later on in the joint mediation that there is an issue which has arisen, which means it wouldn't be safe to mediate, and that hasn't been, or that's putting a child or one of the participants at risk, and it hasn't been reported to an outside agency by this point, the mediator has a very strong safeguarding duty, particularly in respect of children, to consider with the participants how that's going to be dealt with. And if the participants didn't feel able to report that issue, the mediator would have a duty to report that to the appropriate authorities. But going back to supporting a person who's been through this trauma, the mediator will be looking at providing a lot of signposting to suitable resources. They won't just embark on mediation. You will not be put in a situation where you're going to have to be exposed to the other person, or a situation where you're on your own. As support mechanisms will be put in place, and the mediator will be prioritising that with you. I hope that addresses that. It's a big topic.
Definitely, thanks. I think it's quite reassuring to hear your opinion and how you practice on that. I am going to be cheeky and just do one more question. This is case specific, but I think it could be a good example for other attendees on the call. So this one is: my ex-husband and I are totally amicable, but have very different incomes and need to get our head around a fair way of splitting the value of our home and assets. I appreciate mediation will support us in coming to an agreement, but will mediation be able to give us the information on what is considered fair by the government legally? We both recognise that it probably won't be a 50-50 split, as our incomes are quite different, but need to hear from outside of us so that we both can accept it.
Oh, bang on. This is music to our ears, isn't it, Sarah? We want people to be working like this. And absolutely, whilst we cannot give legal advice, absolutely not, because we know our boundaries. I mean, me and Sarah come from a legal background. We'll give a lot of legal information. I mean, I always share advice now, tools and resources. I don't know if you do, Sarah, but they're brilliant, aren't they? They give the law in relation to both children and family and pensions, complex topics, but they break it down into really simple language. And whether you use our services or not, it's all there available in the internet. And certainly on my resources page, I've kind of linked, to all these useful tools and resources for couples who are going through divorce and separation. So absolutely, the couples that want to try and work together to keep costs down, to keep both the emotional and financial costs, mediation is the way forward. We are going to empower you with lots of tools, resources, and information so that you can hopefully come into session and be prepared. And Sarah, I think we would always say, you can take a horse to water, but you can't make it drink it. So they've got to prepare for the session. So whilst we share tools and knowledge, resources and information, if the participants haven't done their homework, then it's going to take longer. We may need more sessions, because yes, we can go through it online at the session, and absolutely that's not a problem. And sometimes we do need to touch on certain complex areas, don't we, like pension sharing, and trying to break that down so that the participants understand it. But these are the kind of typical cases that me and Sarah will always deal with. I don't know if Sarah wants to add anything to that.
Just that we will go through the financial disclosure process in mediation, just as you would for the court or any of the other family law processes. So it's not a light touch process.
No.
It's a soft option. It's something where you will be, and then that will be a package of information that you can show to your lawyers or use in other processes if you don't complete in mediation. So, and the mediator can't advise you, but if they think that one of you is trying to force through something that's unfair, they will give you a heads up that maybe need to have another think and put yourself in the other person's shoes. And finally, I would just say we can't change whatever's happened to you in the past or whatever's gone on. So we won't disrespect that or ignore it, but we're there to try and sort things out for the future. So
yeah, that's important, isn't it? We're meeting you where you're at now, but it's future focused. We're not counsellors, we're not therapists. We can signpost you to other professionals who can help with that, but it's just to understand this is the future focus sort of environment where we're trying to get you from where you are to where you both want to be, hopefully in the least self-destructive way possible, keeping the costs both financially and emotionally down, right? Just a final thing on the disclosure, I guess the important thing to recognise is whilst the mediation process is totally confidential, most of it, unless obviously there's a vulnerable child or an adult at risk where we may need to notify authorities, the financial disclosure piece that Sarah's just talked about, that is done on an open and transparent basis. So if mediation breaks down, of course, you'll be allowed to put your formies and supporting documents into the litigation process. Important to note that.
sorry
now, if we come to time now.
Yes, and sorry if we haven't been able to get through your questions. I can see there's a few more on there, but many of them are on a theme. So hopefully we've touched on what you needed to know for today, and it's very much an overview, and there's a lot more information online. So yeah, thank you.
Yeah.
Thank you for participating today.
Thank you both, and thank you for everyone joining us today. I'm now going to end the webinar. Have a great day, everyone.
Bye-bye.
Thank you. Bye.